To all, we are starting the medico-legal session now. The theme of the medico-legal session to start is that whenever the doctor is practicing, he is very happy that I am practicing. But when the legal litigation starts in his practice, either on the hospital or on the professional, that is doctor, then the problem comes and he becomes disturbed. So from this, we are saying that he should be prepared for what to do when it happens, particularly when the notice comes from a consumer court or a criminal court. It becomes very difficult for him to handle that, and his whole mood changes. His psychological disturbances are there, and all that happens, and for that we should be well prepared, because we are not taught anywhere in our clinical education, that is in the either the undergraduation or the post-graduation. Unfortunately, people don't like this session because they don't want that something can happen with us. So, but when it happens then it is the problem, and then they feel that it would have been better we have attended it. So it's okay for those who are there. It is a very thing is that we should start this session, and we are spreading this knowledge slowly, infiltrating. For that, we are taking the seminars, webinars, and all that. And the medical legal, shortly we are coming with the SOPs that how the doctor should behave whenever he is working as a professional. So, with the first session, that is myself, Dr. A. Deshpande, will start as a लास्ट में हाँ फिर बाद में आप ओके लास्ट ठीक है ठीक है thing is that the criminal previously the criminal law was there, which was prepared by the English people. And their thinking was that they were colonial people and they wanted to rule us. And so the criminal laws were more of the punishing nature and not of preventing or other side. But since we have independence, about 75 years we have completed. And at this stage, we could form a new criminal law, and it is passed in Parliament and Rajya Sabha, and it is signed by the President, and it is now the new criminal law has come into the existence. So what have they done? They have not amended the previous criminal law, but they have peeled off, means totally cancelled that law. The thing is left from that law. But while doing it, so many cases are there pending in the courts. The cases which are lodged in the court, they will continue with the same law, old law, because that is lodged under that law. But now, the new cases will be lodged from new law from the 2023. The IPC is now called as Bharatiya Nyaya Sanhita 2023. It was the Indian Penal Code, it was previously called as. And the Bharatiya Nagarik Suraksha Sanhita now, the Indian the Code of Criminal Procedure, CRSP, that is previously to be called, is now called as Bharatiya Nagarik Suraksha Sanhita. And इधर से आ जा कुरेश, इधर से आ जाओ, अरे अकेला कैसा बैठेगा और तीसरा जो इंडियन एविडेंस एक्ट, that is Bharatiya Sakshya Sanhita. Now this Indian Evidence Act is divided into two, that is the criminal evidence and civil evidence. So both they have not changed, civil evidence still there is going on, but criminal evidence they have totally changed it, and now the whole criminal law is totally changed. And now whatever the new cases are there, they are lodged according to the new law, and old cases which are already lodged will continue with that. कुछ प्रॉब्लम आ रहा है क्या साउंड का? बहुत बड़ा आवाज है. परफेक्ट है, ठीक है. So the Bharatiya Nyaya Sanhita 2023, this is the book, that is a bare act which is available at present, and it is a very easy and very good. So I have printed this for your sake. You can have, anybody can have that with a minimum cost. An act to consolidate and amend the provisions relating to the offences and for matters connected therein with a incidental to it. So this act is for the matters of the criminal. It is proposed to enact a new law by repealing the Indian Penal Code to streamline the provisions relating to the offences of the penalties. So what I have said just now, it is the same. The new additions which were not there in the previous criminal law, and that is proposed to provide first time community services as one of the punishment for the petty offences. This community services was not there in anywhere in the previous criminal law, but that was a colonial law. Now we are independent. We should know that if small thing we do the crime, so we should provide some services to this, our society, because we have done the crime for the society. So from that nature, the punishment is started as a social work. To deal effectively with the problem of organized crimes and terrorist activities, new offences of the Terrorist Act and the organized crime have been added to the bill with the deterrent punishment. Previously, there was anti-national activity. Now, it is not that anti-national, it is not now, because there was a ruler and we were Indians. And the ruler, against the ruler was everything was anti-national. But now it is a terrorist. We are ruling. We the Indians are ruling in India, and we are the prime of the India. But the terrorists are there, and for that purposes they have organized the crimes, and the Terrorist Act has been added to the criminal, which was not there previously. A new offence on the acts of the amend rebellion services activities, specialist activities, or endangering the sovereignty of the unity and the integrity of the India has also been added. The films. So they have added what? Whenever the integrity of the India is going to be broken by the people, they stop it, and for that there is a provision which was not there in previously. They wanted to divide this area, that area, this area, English colonial the kings, where their rule was divide and rule. But now we don't want that, we want unite and rule. And from that aspect of that, there is there is a union to form, and whenever there is a tendency of dividing or endangering the sovereignty of the unity of the integrity of the India, there are the laws are made now. Some important clauses related to the medical profession when we are now dealing with because of the medical profession, that is 304A. previously the table death and all that used to come, now it has 101, 105, and 304B, the 4B, that is 161, the causing death by negligence. 19, and so we have enumerated, and we are going to discuss in detail, so I am not going through that. Old IPC 304B, new BNS section, so instead of reading that, causing death by negligence. Whenever caused the death by a person by doing any rash or negligent act for amounting to culpable homicide, shall be punished with imprisonment of either description of. So this the punishment is for other people, that is 7 years, but for doctors it is 2 years. But punishment is there, but there are so many afterwards clauses that can save the doctor, and those are 101. Culpable homicide is not murder when the person whose death is caused being above the age of 18 years suffer death or take the risk of death with his consent. So, if the consent is proper, if you have taken the consent, even the death happens, it does not fall in the culpable homicide, and so it is not punishable. If the consent is not there or the consent is not proper, you may be punished for 2 years behind the bar. So the importance of the consent has come very large, in very important, and how to take the consent. For that, the all India Ophthalmic Association has published a booklet, and it is been transferred for many other languages also, state languages, so that they can write down the consent like that. If in that pro forma, if the consent is really taken and not the signature only, because I specially made the provision there, I myself was to look up to the medical legal. So instead of the signature, because I have experienced that signatures, they do wrong signatures or false signatures, and in the court they said this is not my signature, and they can prove that that is not his signature. So I have made, previously it was signature or thumb, now signature and thumb. So this is a very important. Nowadays we should see that whenever a patient comes to your OPD, first take his thumb and capture his signature. So identification is nowhere becomes the problem, because everywhere identification is the problem in the court. Doctor cannot identify her because some previously used to write some moles somewhere, hair moles, and there are so many moles on the body or something, so it is not. But nowadays it is easy. Let's put the thumb. So explanation for the purpose of this subsection, registered medical practitioner means a medical practitioner that specially nowhere in the previous criminal law medical practitioner or RMP was said, but now it is specifically said the RMP is exempted for this after taking the consent. Explanation: this session is subject to some provisions as exception 1 of the section 101. This is the section in which double death generally requires under say 100, but now 106(1), that is with consent, there is no punishment, that I have already explained. Accident in doing a lawful act done by accident of misfortune and without any criminal intention, that is not a negligence. An act likely to cause harm, but done without criminal intention and provisions or the other harm. So all these acts are there because there is no doctor wants that his patient should be troubled or should receive the harm. But for doing the good thing, he does the thing, may be reflect in the bad way, and so all these are there. Act 30 is done in good faith for benefit of a person without consent. So, for the benefit of the person without consent also can be done, and this is Bharatiya Nagarika Sakshya Sanhita, and this is in no addition is definition, and thank you very much. So, all these is totally changed.
So, thank you, Dr. Deshpande, for that wonderful exposition. In fact, due to personal reasons, Dr. Prakash Marathe is not able to come here. So, Dr. Deshpande has covered somewhat. He has explained, apart from the general understanding of the new criminal law, he has emphasized on changes in the new criminal law too. So, the next topic for today's session, management of table death in new criminal law by Dr. Quresh Maskati. I request Dr. Quresh to
Yeah.
yeah.
See, the key is that every profession should have a professional insurance. And that's the important thing. The problem in India is not about basically 100%, as in your talking. Now, the thing is that most of the times there are these issues of the villages are everywhere, and they go to the court for this thing, maybe intentional, non-intentional. The thing is, say, I can give an example of that. You put a multifocal, but you have to tell the patient that you cannot drive. You cannot drive. Possibility to become TR. And verbally it is told that you cannot drive, but the patient says it will be multifocal. Okay. Later on he says that I cannot drive. Doctor said that so the thing is now it should be written. It should be written, consent, that I put a multifocal, but you cannot drive. Then he can go to. The thing is now that every professional of ophthalmology should have a professional insurance, because the thing is that the court is open. Court is open. And most of the times, you see, our ophthalmology status stuff is usually a day surgery. And then sometimes you operate a squint under GA in a child. And that the thing happens that there is an anesthetic problem. It has happened. And usually what happens is that it is the surgeon who is caught, not the anesthetist. So the thing is that the key is, just like in the European countries, that they don't do without the insurance. Every doctor should do a professional insurance.
Yeah.
Every consent has to be individual consent, or the printed format we have to fill up the names and
Yeah, on that also the Supreme Court has given a judgment. Because the consents are to be so big, it cannot be written by the hands of the surgeon or the patient. So there can be printed form in their own language. And that printed form should be for particular surgery. If you are doing the cataract surgery, the form will be for the cataract surgery. If you are doing the squint surgery, it will be the form for the squint surgery and not for other surgeries. Universal form which is available in the market, they are not accepted. So you can write the name of the patient by patient can write his own handwriting or his relation or the doctor, and he on the last thing he has to write that I have gone through all this, everything is explained to me, and it is acceptable to me, and then he signs on the printed form. So printed forms are not available. Only you put the surgery name, you put the name of the, that is not for particular surgery. You can have a printed from your computer. Yeah. You have to feed all the things to your computer and take it from the computer. So it becomes very easy. Yeah,
we have been doing like that.
yeah,
Otherwise, there was a judgment.
yeah,
The judge said, "Oh, you are having this form and you just fill up the name with hand, and
yeah.
this is not acceptable."
Not, that is
It
not.
should be individual.
Individual,
It
yes.
becomes individual
Yeah.
if we bring it out from the computer, and
Yeah.
his name is also written in
Yeah,
computer
yeah,
language.
yeah. In High Court of Maharashtra, previously people got there, and they gave the decision that no printed form is accepted.
Yeah.
But that was gone to the Supreme Court, and Supreme Court has refined that this. particular surgery or particular thing, everything should be separate.
And there we can
Then,
fill the
yeah,
names with
yeah,
the hand
yeah.
and then
Signature,
get it
signature
signed
and thumb.
basically. And thumb impression.
Yeah.
That you have told very great.
That is mandatory done in our thing. Yeah, anesthesia form is different. Anesthesia form is different and anesthesia consent is different. Anesthetist has to take the consent and the surgeon has to sign that also.
Sir, for the NABH, there is a separate consent form. So now what we are doing is we are taking both the consents from the NABH and from the
Yes,
AIOS.
yes.
So we have to take
The
both.
NABH consent is a record consent. That is for the record purposes. That is mostly not medico-legal proof consent. So there are many lacunae. So better to have our AIOS consent, and you can side by side you can have an NABH consent for NABH people. Yes.
And so
Uh,
one more question. Like guarded visual prognosis, if we take that consent from all the patients of cataract, is that a problem or we can take it?
Guarded you cannot take, you can explain the complications and what can happen. All the complication you can mention in the form. So you cannot say that there will not be vision or there may not be vision. So these thing can happen. That is mentioned in our AIOS consent. If you go through, everything is covered in that.
If it is a guarded visual prognosis, you need to specify for what. If you
Okay.
mention the word,
Eye seems to be amblyopic, so there's maybe less vision.
you have
Yeah,
to specify.
that is already mentioned.
Why should somebody operate an eye which is unlocated? Why should somebody?
There is another one consent is that is a consent in some emergency cases or some places where special consent is taken that we are doing this for the sake of purposes of charge and so there may not be good results. That type of consent also can be given. That is also there.
One police officer of mine, he's my friend, he told me that get the words written, this is being done in good faith.
Yeah, that's true.
It's only in UK and USA that there is a chronologic order from A to Z. This is going to happen. But probably in India, if you say that, probably the patient may not come to you. And when it is the amblyoptic eye, why should you touch it? Right.
No, I have had amblyopic eyes with completely hypermature cataracts. It can happen. So the patient tells me that I have not seen through this eye since the age of 5 years. But he's got a hypermature cataract there. So I tell him, I'll have to remove your cataract. You will not see. You will see what you were seeing when you were childhood. But your cataract is mature, we have to remove. So then you need to mention. In a few cases like this.
That might get basically complication.
Lens-induced glaucoma.
Stuff like this, just look at it,
Exactly. Exactly. Exactly.
Should we start?
Yes.
Yeah. Dr. Quresh will give his lecture. The thing that what happens when the table death happens, as he said just now, and lot many problems are there, social problems are there, to convince the relations is there, medico-legal problems are there, and Dr. Quresh is going to explain everything on that and how to manage it. Dr. Quresh.
So I'll take you straight to a true life story which happened to me. This is based on an actual incident. This patient had multiple medical problems. You name it, he had it. Thyroid, diabetes, hypertension, heart disease, obesity, and collagen disorders. Patient had all these. He came from Indore. The eye surgeon from there called me up saying there's bilateral corneal perforations. You manage. So when the relatives came, I spent almost 1 hour with the relatives, explained the necessity of general anesthesia because I needed to try to save both eyes. I wanted to put bilateral amniotic membrane grafts. Relatives were briefed about the possibility of death on table. My anesthetist and I spent 1 hour with the relatives. There were about 4 relatives who came from Indore. And we chatted with them that is a very, very high anesthesia risk. But to try and save his eyes, otherwise he will go blind in both eyes, we have to do this surgery. The inevitable happened. Patient, luckily for me, had successful surgery, came out of anesthesia, was wheeled out of the OT on a trolley, and actually said hello to the relatives. So he said hello. Then he had a sudden cardiac arrest before he could be shifted to the room. So it happened outside my operation theatre, but before he could be shifted to his private room. So the anesthetist was present, I was present, relatives were all there when it happened. So of course we rushed him back into the OT and tried to resuscitate him. I have the cardiac monitors, I have the defib machine, all of that is in my OT. We called the ambulance to shift him to the ICU. Across the street, I have a general hospital with an ICU. But he was declared dead by the cardiologist who came with his ambulance from across the street. So what next? Relatives were initially very understanding. They said, give us the body. You've explained it to us. We understand. We took that risk. Give us the body immediately. We'll take the body back to Indore by train. Indore is in central India. I refused. I called in the police after making sure that my operation theatre notes and the anesthetist notes were complete in every way. That means minute-to-minute notes were written. The police took their own sweet time in coming, about 1¼ hours, 75 minutes, and asked me why I bothered to call them. Because when they came there, they talked to the relatives. Relatives said, we don't want anything, we just want the body, we want to take it back. So the cops said, why did you call us? Simply get a friendly family physician to certify cause of death as heart attack. Give the body to the relatives, they are sitting here for disposal. I refused because I didn't want legal trouble later. Today there were 4 relatives, tomorrow there will be 40. So the legal thing in Mumbai is to ask for 5 witnesses. They are called panchas. Pancha is 5 in local language, to be present while they talk to the relatives. So 5 witnesses were my OT staff and my ward staff were called as panchas, and they talked to the relatives. They took their own sweet time chatting with the relatives. The cops explained the further procedure. After the Panchnama is the preliminary inquiry in the presence of the 5 witnesses. They would send the body to the JJ hospital, which is the state government hospital. So we are in a municipal corporation, but there is the state government hospital where a post-mortem would be conducted, authorized by the coroner. We have a coroner system in only 4 metros in India. So the post-mortem would be conducted. It is mandatory to have a post-mortem for somebody who dies within less than 24 hours of admission to a hospital. Only then would the death certificate be issued. This would be then taken to another government office. We should issue a permission certificate for the body to be taken out of state. The cops took their time explaining and made it sound as if it was as difficult as climbing Mount Everest. Since I had a clear conscience and the relatives were cooperative, the cops were getting frustrated. They took over 2 hours. So they took 1 hour, 15 minutes to come. Then they took 2 hours to record just 2 pages of statement. Finally, they called the government hearse to take the body to the JJ hospital morgue. Now the relatives were getting tired. This death had occurred at something like 10 or 11 in the morning, and it was like 2, 3 in the afternoon, and the body was still there. Nobody had eaten any food. Everybody was getting tired. So when they took the body to the morgue, I had sent my hospital manager with the patient, with the body, and the cops and the relatives there. But the class 4 employees, the peons in the morgue, told them that there are so many bodies waiting in queue for a post-mortem. So things could get delayed by hours, maybe a day, 2 days, unless they gave him speed money under the table or a bribe to expedite the post-mortem. Though I had sent my hospital manager, they readily agreed and took out money and gave the peon all the money that they had. The post-mortem was finished now in less than an hour, and the certificate was issued. The morgue attendants, having been well fed, themselves accompanied the body and the relatives to the railway station, completed whatever paperwork was required. There was no other office to go to. Got the train delayed by 10 minutes. You could be the Chief Justice of Mumbai High Court, you can't get a train delayed by 1 minute. But these guys got the train, they talked to the station master, they did whatever, they got the train delayed by 10 minutes, put the body in the luggage compartment, they gave the relatives second-class compartment tickets for the 18-hour trip home. So the lessons to be, in the meantime, I had called up the embalming people. We have good embalmers who, for Christian deaths, they embalm the body because they keep it for 2-3 days before the funeral. So I had called up the embalmer saying that this body will come, will you embalm it, will you keep it? And then I was going to arrange the body to go back by flight to Indore. But these people took it away, and then my hospital manager called me to say this had happened. So what are the take-home messages that I learned which I want to share with you? Number one is stay cool. Take the relatives into total confidence right from the beginning, not after the surgery. If patient is bad risk, tell them about it before surgery. Of course, as Dr. Deshpande says, record everything, the consent and everything, but more important is actually talk to them about it. When death occurs, don't leave the hospital under any circumstances, because leaving the hospital is a sort of admission of guilt that you're scared or worried about what will happen. This happened to a friend of ours, a reputed eye surgeon in Mumbai, who had a hospital death. He was in no way responsible. Some residents had operated. Patient died like a patient can die of a cardiac arrest. But he left the hospital premises, leaving the resident doctors to talk to the cops. When the cops came, the cops asked him, where is the owner of the hospital? The owner was at home. The cops told him, you please come here to talk to us. He says, I'm not coming. I've talked to my lawyer. Whatever it is, you talk to the residents. So he threw the residents, down the gutter, which is something which you shouldn't do. That annoyed the cops, that annoyed the relatives. After all, they've paid fees for this hospital with a reputation, and the owner is not coming there. So what would have been a simple case like in mine escalated into a conflict. So if you're there, don't leave the hospital. If you're not there when that occurs, come to the hospital, take the buck. It's not so difficult. Important thing is to understand the law, as Dr. Deshpande has said. The BNS is now more in favor of us than the old law. So call in the cops, be proactive, call in the cops, insist on this, and insist on the post-mortem. So in page 13 and 14 of the AIOS CME series on legal aspects of ophthalmology, 27, compiled by Dr. Deshpande, doctor is not arrested, though it is a cognizable offense under section 304A, now BNS section 105 as he explained, according to the Supreme Court ruling. A death at our hands, either with consent or without consent, if the surgery is done in good faith, as you mentioned, doctor, with your police friend, earns us exemption under section 88 of IPC, which is now 25 in BNS, and 92 of IPC, which is now 29 in BNS. Do not try to bribe the cops. Do not submit. You don't need to bribe the cops. Don't submit to blackmail by relatives or pay them any money to hush up the matter. Again, that is an admission of guilt. You have explained to them it was high risk, patient died. So no blackmail. At the most, you may not charge your surgical or nursing home charges or refund them whatever you have charged for the surgery as a goodwill gesture, making it clear that this is not an admission of guilt. I was prepared to refund the money and use that money to send the patient, the body, back by flight. So that's the maximum. No extra money is to be paid. So in conclusion, don't wash your hands of this situation. Stay in complete control. You will never need to spend a minute behind bars like this if you do not panic. May you never face such a situation. Thank you.
Thank you, Dr. Quresh, for giving such a nice lecture on managing a death on the table or the hospital. I request Dr. Mathur, he will be speaking the effect of the litigation on the medical profession. As such, the previously effect was only of the criminal. Civil, it was okay because insurance was there. But now, the criminal has given so many things in favor that when negligence is not there, the doctor cannot be sued. And Dr. Mathur is giving, when it happens, what happens to the medical profession? Dr. Mathur.
Yeah, because of collagen disorder and all the other stuff.
Usually happens in this rheumatoid arthritis.
Yeah. Exactly. Exactly. It was a really terrible thing.
And I think one very good point you have mentioned, don't run away from that place.
No, you must
Yeah,
be
yeah.
present.
Inform the police. And if you inform the police will protect you from the mob. If
Yeah,
somebody-
exactly.
they collect.
That's true, that's
This
true.
just happened with my friend. So there was a death, after the surgery.
Yeah.
And he didn't leave the place. And the police came, and by that time we had also reached.
Yeah.
And police, they assaulted him,
Took him to
escorted
safety.
to the safe place, telling them that they have arrested.
Yeah.
Sometimes even if you on the surgery there, they vandalize the theater.
Yes.
They vandalize all of things.
So we have in Mumbai we have a professional body called Association of Medical Consultants. We've tied up with a firm which has armed bodyguards, bouncers type of thing, and they come within 15 minutes to your hospital on call. We pay for the association pays for the services. Wherever you are, it's like an ambulance service, but they've got heavyweights who come there and they help to protect you from the mob, from physical violence.
They have, just nearby from this place, they have a IMA task force.
Yeah.
If anything happens, they put a notice that something
Same.
has happened at this place.
We have the same.
Doctors will reach there.
We have the same thing in Mumbai. It works. Yeah.
I've seen in Middle East that every hospital that they have got the police.
Yeah. Yeah, but in India, 70% of all our ophthalmic surgeries take place in small, what we call nursing homes or daycare centers. So not in the large hospitals. So the protection is very minimum.
I have a question. It might be lucky that the patient was able to say hello to the relative
Right.
while he wheeled out. If it would have happened in the OT before he could be wheeled out, and if there was no high risk present, like a patient who was relatively a diabetic and you did a surgery and unfortunately had a cardiac arrest on table, how would these two situations be different?
I think it would be exactly the same. It would be exactly the same. You need to be present. You need to tell them that anybody can have a heart attack while walking on the street as well. And this is what has happened. You just tell them. Every layman understands heart attack. So you say he had a heart attack. You don't have to go into finer details. We've tried to revive him. We have all this equipment and everything. We've called the ambulance, but it happens. Yeah.
The Middle East, the thing is that India, you do the cataract surgery under local surfaces. They just copy the USA, every surgery is done on the GA. So this was a patient about 60 years who had diabetes, hypertension, and had a cataract, and my colleague put an IOL. It's about 20, 30 years back. And he had all the things that the diabetic screening, hypertension screening, cardiologist, number, everything. So the patient was operated, and then he just came out of the anesthesia and had a lunch about 4 o'clock. I was at call, second on call. She called me. She is not able to talk. But the patient which Dr. Jayakumar operated took the meals is dead. But the thing is that when they screened everything, but the most important thing is that the patient, after surgery, after anesthesia, took this meal.
Yeah, yeah.
The thing is, what happens sometimes is that the elderly patients who have got this sort of this thing, the GA might trigger a silent GMA.
Maybe.
I think one more take is those who are doing solo practices and they don't have all the equipment for general anesthesia and all these things. They may be in trouble.
No, so
You had everything.
no, but see what happens is even AIOS has recommended that if you are in solo private practice, either have an anesthetist standing by, which is preferable. It's not mandatory, but it's preferable to always, even if you are doing a topical anesthesia, have an anesthetist standing by. In smaller towns, it's difficult to get an anesthetist. Get an MD physician available to you. And make sure that you know the nearest ICU and how fast you can get the patient there or the ICU people to come here. These are things that before you start practice in any small place, these things must be in your hand to prevent medico legal.
There you can do a
Case
MOU.
like yours, that should not be done in their place.
Yes,
Yeah.
cannot.
Yeah, you can.
Don't tackle such cases.
You can do the MOU with the ICU
Yeah.
when you start the practice.
Always you have a tie-up with a nearby special hospital where the facilities are.
Correct. Absolutely true.
Every practitioner cannot have
The Maharashtra Ophthalmic Association has put a daycare center bill, and in that provision is there. Unless you do the MOU with the ICU center or the hospital, you should not start your daycare center.
Just a last question, sir. In such situation, should you call the relative inside the OT if such an untoward has happened? Does it have any value in evidence or something?
Any value in evidence? No.
No, you should not call the relatives in the OT, but you can call them in your chamber and you counsel them nicely.
Yeah, yeah. Yeah, yeah.
See, once he is inside,
You can break your microscope.
after 10 people will there, you will theatre gate.
Yeah. Yeah. Come. Come, Manoj.
It happened to me once. A old lady I operated counseled earlier having a cardiac problem, intumescent cataract, secondary glaucoma. And under GAVDT, everything went well. She never recovered. Then I had an anesthetic. I have an ICU also in my hospital because mine is a multi-specialty. Finally, I had to take the patient out, take to the ward, keep them for some time, and I called them, called the attenders, counseled them, then everything.
Come.
So let us move on with the next talk. I shall be speaking about the effects of litigation on medical profession. And before I like to proceed further, my sincere thanks to Dr. Deshpande for his constant guidance to me as far as the medico-legal issues are concerned and in all my presentations. The Supreme Court stated that medical service is a service industry. The medical profession came within the ambit of Consumer Protection Act because of the landmark decision of Supreme Court in the case of IMA versus VIP Shanta and others. So till the decision of the Supreme Court, the medical profession was a healthcare industry. The Supreme Court decision in this case, which brought the medical profession within the ambit of Consumer Protection Act that changed a family doctor to a corporate hospital. The impact of this was, the judgment was a significant step in expanding the scope of consumer rights in India, especially with regard to medical treatment. It reinforced the idea that consumers, that are the patients, have the right to seek redress in case of medical negligence, making it easier for the patients to file complaints and seek compensation in consumer courts. This ruling also led to greater accountability in the medical profession, pushing healthcare providers to maintain higher standards of care and professionalism, knowing they could face legal consequences for medical negligence. So, an unsatisfied patient, when the patient becomes unsatisfied and goes in litigation, maybe because of poor clinical results, behavior of the doctor, behavior of the staff, including the ambience in your setup, instigation by some people, and also frivolous complaint to earn some money. A patient can file for deficiency of service in any of the following. He can go to the consumer forum, or a civil suit in a civil court, a criminal court case, if he can go to the criminal court, and he can approach the Medical Council of India or a state medical council, or sometimes through politicians, ministers, member of parliament, or members of the assembly. Or they can approach even the bureaucracy, like the director of the deputy director of the medical or health services. So under Consumer Protection Act of 2019, there is the CPA, the doctor or hospital is sued for negligence under clause 35, for standards of services again 35, Product liability action clause 22, 34, and 35, and not for complications. Complications are not conceded by the court. The complications can occur to anybody, and that leeway is given, which are mentioned, the complications that are mentioned in the research papers and in the textbooks, they are not held accountable against the medical profession. So, Section IPC 45 of 1860, Section 304A, now called the Bharatiya Nyaya Sanhita 2023, has come under clause Section 21061, as Dr. Deshpande enumerated, that is causing death by doing any rash or negligent act. The table death is generally inquired under Section 304A, now BNS Section 1061, as Dr. Quresh Maskati pointed out, and an FIR is registered, but the doctor is not arrested, though it is a cognizable offense, it is a bailable offense. So the Supreme Court, in the case of Dr. Suresh Gupta versus the government and city of Delhi in 2004, it is held that for every mishap or death occurring during medical treatment, the medical man cannot be proceeded against for punishment. So complications as a result are bound to occur in any situation, and for that the doctor need not be arrested. The impact of litigation, coming to the core topic of my talk today, litigation significantly impacts the medical profession, leading to increased stress, financial burdens, and potentially affecting patients' trust and doctor-patient relationships, with some doctors even facing career repercussions. So what are the effects of litigations we should classify for the doctors, for patients, and for the healthcare system? Impact of litigation for doctors, stress and burnout. The fear of lawsuits and the legal process itself can cause significant emotional distress, leading to increased stress, anxiety, and even burnout. Defensive medicine. The constant fear of litigation can lead doctors to practice defensive medicine, ordering unnecessary tests or procedures to protect themselves rather than focusing on the best course of treatment for the patient. Financial burden. Medical malpractice lawsuits can lead to substantial financial settlements, legal fees, and insurance costs, placing a significant financial burden on the doctors. But as Dr. Gaurav said earlier, medical insurance is a must, is a requirement. All practitioners should protect themselves for professional indemnity to avoid such situation. That one product relieves so much of stress from your mind. So the impact of litigation for doctors, reputation is at stake. Even if a lawsuit is unsuccessful, the allegations of medical malpractices can damage a doctor's reputation and professional standing. Impact on career. Legal battles can harm a doctor's professional standing, affecting career advancement and opportunities. The court goes on, gives date after date after date, and you sacrificing your practice have to appear before the court for against all the summons, and that really impacts your mindset, impacts on your career. Burnout and depression. Physicians involved in malpractice suits are found to have higher rates of burnout and depression, as well as decreased career satisfaction and loss of clinical privileges. In severe cases, doctors may lose their clinical privileges or even their license to practice medicine. The impact of litigation for patients is a loss of trust. Medical malpractice allegation can reduce the trust that patients place in their doctors, leading to skepticism and anxiety. Patient distress, apart from distress to the medical profession, the experience of being involved in a medical malpractice lawsuit can be distressing for the patients if they are on the right side. You have to understand the other end of the spectrum too, both emotionally and psychologically. And reduce access to care. Some doctors may avoid certain procedures or specialties due to fear of lawsuits, potentially limiting the access of care for the patient. And for the healthcare system, increased costs are associated with medical malpractice litigation, including insurance premiums and settlements, can increase the overall cost of the healthcare. Reduced innovation. The fear of lawsuits can discourage doctors from adopting new or innovative treatments, as they may be hesitant to face potential legal challenges. And impact on patient safety. While some argue that litigation can improve patient safety by holding doctors accountable, inducing extra involvement from the doctors, the other end of the spectrum, that it can lead to defensive medicine and focus on avoiding lawsuits rather than providing the best possible care. Thank you for your patient hearing.
Dr. Mathur has said just now, uh, the effect of litigation on medical profession, that is true. But apart from that, the individual doctor who gets it, that is totally different. Because psychological effect of litigation is such a thing that when we start the practice, we never feel that such thing will happen with you and the litigation will come to you. And as a young person, when you are starting the practice, you are very much happy that I am starting ophthalmic practice, I am starting ophthalmic practice. But when the litigation starts with you, you get disturbed because the aims and objects of your is to give the services and good to the patient. But when the patient keeps a litigation on you, then the problem comes. Kajal. So the psychological effect is such a thing that when a notice is given, either from the criminal, civil, or consumer, whatever it may be, or the inquiry officer, as Dr. Mathur has said, there is a notice can come from anywhere. So psychological effect on the doctor is that he is disturbed totally. And this disturbance is not to only him, but it goes to his family. He becomes irritable in the family. He remains aloof, or he is become violent, or whatever it may be in the family. And it is not the only family, but on the patient itself. Because whenever he examines the patient, he comes into the mind that whether this patient will go again to the litigation. And his mind is disturbed totally. Psychological effect is very, very different, and all the patients are affected by that. So, keeping a litigation on the doctor is destroying the treatment of the other patients, actually. So, that happens, but that depends upon the person to person. Variations are there. There are people who are very sensitive and go thinking on that, but some people are very sure that, okay, this is going to happen, I will face, and they are courageous enough to face. So that attitude should be now there, second attitude, and not the first. Because it is when you are going to do the practice, you should expect that there should be litigation. And anxiety and stress, litigation often triggers intense anxiety due to the uncertainty of the legal outcomes and professional potential of professionals. The stress, the nature that the man, how the person is, whether he is an introverted patient or an extroverted patient, that depends upon him. If he is an introverted patient, he definitely will get the stress. Even for small things, if I have to fly today in the morning, say 5 o'clock, whether I will get up early in the morning, that is also stress. So you are doing the practice and dealing with the life of the people. So lot many stress starts there only for some people. So that depends upon the mind of the person, how he is. That is whether he is an introverted person or extroverted person. So fear of financial loss, including legal fees and potential settlements, that is another thing, but that is a minimal or little bit. Worry about damage to the professional reputation, which can affect reflex and patient trust. So this is a very good, very important thing, because doctor's profession is on trust and his reputation. Trust is reputation. When the patient mouth to mouth says that this doctor is good, it so many people go there, and that is the publicity, from the mouth to mouth publicity, and that was the previously only one source of publicity. Nowadays in corporate, lot many things are allowed. That is a different thing now. Now the medias are there, and you not so many provisions are there. But reputation, particularly in small towns, in big towns, nobody bothers for anything. In metro cities and what happens where nobody is bothered. But in small towns, it is very, very important, and the reputation affects his profession. The upgrading of the legal proceedings, which can stretch over months or even years. As you know, in litigation when starts, it doesn't stop. Neither the results come out in few days. It goes on years together, years together. And so stress is also taken years together. And so the emotional toll of the being scrutinized and questioned about past medical decisions. This chronic stress manifests as sleep disturbances, difficulty concentrating, irritability, and even physical symptoms like headache and digestive issues. As you know, psychologists, they know that stress from anything can come. And the professional stress is one of that. And the litigation is on that. Because professional stress is of your practice. But litigation stress is on that. When the litigation is there, you are more stressed. And the man should be enough courageous or extroverted to deal with all these things. Even a baseless lawsuits can help the feeling of the, because the thing is that it is not necessary that actually the fault of the doctor should be there. Because there are many suits put for the sake of getting the money, sake of troubling the doctor, also done by the colleagues to make him bring down his reputation. So in profession, particularly in corporate fields, it is a very, very tough tussle. And the corporate people, what they will do, you cannot understand even. They will put lot of many cases on the doctors or hospitals when there is a good reputation on that hospital. They will make it to put. And another thing is, what is worst thing, I should not say, but it is happening. In New Consumer Protection Law 19, so there is a provision of mediator. And the mediator is given the powers of compromising. So whenever there is a litigation, the person, the lawyers, I am not blaming the lawyers, not anybody, not the patients. But that is the attitude I am blaming. Attitude of the people, not of any profession. They feel that if I gain the money, what is bad in that? So he goes to the patient, says, well, you want money, you have gone to now, you 5, 6 lakhs, 7 lakhs, 10 lakhs. Oh, he says, sign here, that's all, you go. I will not call you. He will go to the doctor. Doctor, your practice is not good, I think. So, well, will you like to have 10 lakh rupees? Just sign, I will put a case on you. You don't worry, you did not come to that. I will manage everything. They will go in the court. We'll put the case from the patient side. That will case. Now the provision is bad. The provision is bad. Every case will go to the mediator. And the mediator will try to compromise. And this patient, he sees how much insurance is, 1 crore insurance is there of the doctor. So we will compromise for 50 lakhs. So both advocates will come together and mediator will compromise for that 50 lakhs and everything is over. So this is happening. This is going to more happen in the future because of the tendency. I am blaming the tendency, not the post or not the profession. The tendency is bad. And if that happens, the cases will increase. The increase premium of the insurance will increase, and ultimately that will go to the patient only. So that false cases are there, and that are more troublesome. Self-doubt, the stigmas of the being use many causes, embarrassment even of the, so other things, hopelessness, the lengthy and draining legal process can make the ophthalmologist feel trapped, especially if the case affects their ability to focus on work. So the ophthalmologist cannot focus on his work, and everything remains cases on me. Cases on me. The persistent emotional distress can develop into the clinical depression, affecting motivation, relationship, and overall quality of life. So his quality of life is so his professional life is disturbed, his family life is disturbed. So everywhere he is disturbed. That depends upon the person. Again, I will say, and the professional and personal isolation litigation can lead to both professional and personal withdrawals and ophthalmologist. I am handling, as a chairman of the legal committee of the AIOS, I am handling so many cases on the ophthalmologist. But I only say that you forget that there is a case on you. You start your profession as if there is nothing. That is our thing. We will handle. You are not to get trouble for that, and that is the real thing which should happen. The avoid discussion the case with colleagues out of the fear, actually that should not happen. We should call the colleagues, tell to the colleagues, distance themselves from family and struggle of the confidence and others. So all this burnout takes place with the person. He becomes so much that this is not good. What have so many people now are not ready to take the medical profession. First thing, they are getting the long medical education, then it is the post graduation, and then settling, and after that settling cases. Better not to go for that. So that is also happen, the defective defensive medicine and all this. So this psychological effect is very high, provided the person is like that, introverted. Thank you very much.
These are what he recounted are absolutely true. All of us have seen our colleagues who have really been suffering for years because of some frivolous litigation which is there. I know an eye surgeon in Delhi who pulled up a fellow of his for fudging manuscripts for journals and creating 5 manuscripts with fictitious names of patients, fictitious patients when none existed. And she went and sued him for sexual harassment. And that case is going on since 11 years. I mean, it has been thrown out in 2 courts, but it is still going on above. So this is nothing to do with patient, but anyone can sue nowadays, and it really disturbs the life of the doctor.
Yeah, really what Quresh said is true. Anybody can sue a doctor. And for the sake of money. Because it is very easy to sue a doctor. Particularly in small cities, it is happening that if the practice is very good, somebody will send some lady to him and she will just go. I have gone through this case. One small case I will narrate here. I will like to narrate this case without giving the names, which I have handled myself in the court. A small town where the practice of the doctor was very good and he was doing very well. And somebody did not wanted that it should happen. And so she sent to the college girls. The college girls gone there. And unfortunately, they got examination. She sat on the slit lamp. As you know, the slit lamp is having only one rod. And generally it is mounted up, down table. So the legs are there only. Both patient's legs are also there, doctor's legs are also there. So she said that intentionally doctor touched my legs and tried to trouble me. And she gone to, and she phoned to her principal. That was manipulated. Principal came with about 30 students and they started beating the doctor, destroying the hospital. That is actually happened. And so what happened? So doctor phoned to the police and police came and they said that why you have done the, they arrested the doctor and taken. Because that was unmodesty. She said, he has done me unmodesty. So easy. And the case gone in the court, in the criminal court. Then the case came to me. What I seen first, I taken the cameras, and the previous cameras surrounding the hospital showed that the girl was looking after for that, moving around the hospital, seeing what 2-3 days before. That was one evidence. Second evidence was that her principal came within 10 minutes because there was statement that the statement of the girl was that the phone call was also recorded, the phone was also there, and within 10 minutes the principal came with 30 students. The college was 30 kilometers away. How it is possible? So it is a manipulated thing. They were ready outside the hospital. And third, the thing that she given the, say that she has only touched my legs. If the doctor wants to, that is unmodesty do, why only he will touch the legs only? So all these things with the good judgment that they said that this is done with bad intention. So the doctor is totally relieved from that, the broad. But the thing that happened is gone for 5 years. So for 5 years he was reputation gone, his small being small town and his mental torture. So it is easy to torture the doctor very easily anyway.
Any other points for discussion? Yeah, go ahead. Yeah, we have time.
Like, how does it function?
Yes, legal cell is there, and legal cell is expected to handle the cases whichever are there on our ophthalmologist all over the India. So whenever a case or a notice even comes, you can send to me. You can go on the website and my phone numbers are there, emails are there, and I help without any charges, without anything to the ophthalmologist till the case is decided. Only the thing is required that one has to put his own advocate in the court, but all the things structure that is being made, because advocates are not knowing the medical profession, so they are not good enough to represent the doctor. So everything I do and hand over to them that they have to do it. If they are insured, insurance advocate will come and stand in the court. So that is, if it is a criminal case, they have to select their own.
What we have done on the AIOS website last year, we have formed a grievance corner. So grievance corner basically comprises of 3 sectors. One is adverse events. If you have any adverse events with your drugs and this thing, we have an adverse events committee. The second is trade relations. If you have any issues with your instruments and any issues with the trade, you can go to that. And there is a third tab, any other. If you just submit your grievance, it goes to the secretary and or it goes to the concerned chairman. The secretary forwards that. If you can go to the website, go to the presidential committee's medical legal cell, contact directly Dr. Deshpande, or you can submit your grievance in the grievance cell and that will be forwarded to Dr. Deshpande, and AIOS helps the members in that way.
The other thing is that AIOS has also started a professional insurance agency called Cover You, which is excellent because it gives you and I would urge every member of AIOS to take, as Dr. Yu said, everyone should have a professional indemnity and don't go for lesser amounts because people are suing for higher amounts. So the increase in premium is not so much, but try and go for a higher cover even if you are in a smaller town. Yeah.
For AIOS members, a 1 crore policy costs just 6,400 rupees. Whereas in my personal, this thing, for just a 50 lakh cover, initially I was paying 12,000 odd. For 1 crore, we are paying half of what we were paying. It is the power of numbers that matter, a group that matters. this AIOS Suraksha, what we have launched on the website, by just going to that tab, saying putting in an OTP, you have to just enter your membership number. You get an OTP. By inserting OTP, we have 6 policies on the website. 3 for your professional indemnity, professional front, and 3 for your personal front also, with professional indemnity insurance for personal cover, right from 3,200 rupees for a 50 lakh cover minimum this thing. You can take up to whatever amount you want. For hospital indemnity, you can take cover. And there we have a policy called Cover Prime that includes medical indemnity plus social media intimidation, legal notices cover, all sort of assistance. So there is a prime policy also. And on your personal front, you can approach the intermediaries that is cover you for your personal health insurance. That also matters, apart from your professional safety, professional health insurance, your personal health insurance. Then your term life insurance. We do have FBS. Dr. Quresh is the chairperson for the FBS Society, but there is an age restriction of 49 years. Whereas now we are offering term life insurance for, especially for people over 49 years, up to 60 years of age. If you are interested, you can offer a term life insurance, and then including your motor vehicle insurance also, they are promising a 25 to 30% discount on the existing premium that you are paying. And what they are also offering is up to 4 motor cars. Like some of us well-to-do colleagues, you may be having more than a vehicle, and in a single policy, they will cover all your vehicles, up to 4 vehicles. So it's a comprehensive thing. All 6 brochures are uploaded in the website. You just have to fill a form. And what they are offering as a incentive in the initial thing is, just if you fill your form with all the particulars, so they are going to provide you a complimentary 10 lakh insurance cover. After that, if you pay them and take a, suppose, a 1 crore cover, for the first year you will get 1.1 crore cover, something like that. So that's an incentive thing. Basically, it's a good move with a good intention. And I would request all the AIOS members to make use of this facility, as Dr. Quresh said.
Yes, please.
Powerful than written consents?
Yeah, video consent, but consent should be in writing, and that can be catched in the video, that the person is being told everything, explained everything, and is signing. That video is important. That is definitely having the weightage, but that should be in hard copy only, signature and thumb impression.
And consents should be taken day before surgery or on the day of surgery is also valid.
It is not necessary day before.
On the day of surgery.
On the same day also. Yes, please.
Yes.
Yeah. Yeah.
There's not most of the time, the respect, the understanding between a teacher and a student.
That's what I said. Health care is transferred to corporate law now. Corporate care.
Sir, I have a suggestion. Like, the whole fear is because we don't know what is going to happen. It is about the unknown, because as doctors, we don't know anything about the legal field. So if we have a kind of a flow chart that if this thing happens, then this is the next thing you need to do. These are the options. Then
Yeah.
like if there is death on table, we don't know that the police cannot arrest you. So there should be a flow chart, so we know that they cannot arrest you. Then the local police comes into picture. Even if you are arrested, then the magistrate comes into picture, then the lawyer. So like, if we have learned so much, we can learn this also. This is not too much. It is only the fear of the unknown which is scary.
The medico-legal cell is now doing that work of that. And we are preparing SOPs for everything. That is patient coming from the outside to the counter to he is discharged and follow up. So for every SOP, for every function, that is this happens, that happens, surgery, medicine, examination, whatever you want to do, we are preparing SOPs. The process is going on. So shortly, we will be publishing that SOPs on our websites are also as in the form of a booklet, and that will be available too.
It will
So,
be on our
yeah,
website also.
so we are working, and so many experts are working on that, because some surgery will be expertized by somebody, and that he will suggest the SOPs and like that. But it is doesn't mean that these SOPs are binding to the ophthalmologist. Neither they will be any effect on the court, as this was the SOP, why you had done like that. That cannot be used in the court of law also. So that is also we are making the provision.
And
so
one
like
more
if it goes
announcement.
to the consumer court, then whom we have to approach? We don't even know where the consumer court is.
Those
Yeah.
SOPs will.
Things like that.
That is
If
my
it goes
India's,
legally, then where? If it goes to the state medical council, then where we have to go? Like
yeah,
after that point, we'll try to find out now what we have to do. If we
yeah,
know that beforehand, then it is
yeah,
easier.
legal
It's
cell,
coming.
legal,
It's
cell,
coming.
yeah,
Asking
yeah.
exactly is
Yeah,
what we
it
have
is
to
coming, it is coming.
Okay.
And you, at present, if anything happens, you can go approach to the legal cell, AIOS.
And one
By
more
phone
annou-
also even, by only giving the phone.
And one more announcement I would like to make. Last year we had a very successful certificate course from AIOS called DISCOS that was covering infection control. So shortly, probably, sir, in May or June, we will be launching a medico-legal certificate course for AIOS members. There will be 10 modules, 10 lectures with online examination, and all the members who clear that online exam will be awarded a certificate of appreciation for AIOS on medico-legal aspects.
So everything is ready for that also. Only after the conference we are going to start
Because
immediately.
we need 10 uninterrupted weeks of tuitions.
Yeah.
So the topics are ready, speakers are almost ready, so we'll be launching it very soon.
So,
Thank you for that, sir.
Last
yeah, yeah,
question.
please,
We
yes,
have
please.
time.
We are having time, no problem.
What I understand from this is that only the informed consent holds true in the court of law. So what we write in our OPD, we keep writing risk of this. Are this not required, and where does this stand today?
Yeah, that is true. The informed consent has given more importance in the criminal law, in the new criminal law. That is true. In consumer, informed consent is not going to give the protection at all. Whatever he has accepted, he is a consumer. So consent is nowhere giving protection to you. Only the time that he is allowed to do it. So there is no weightage in the consent in civil cases, but in criminal cases, lot much. The OPD, whatever you write, actually nowadays the national NMC has given the direction that all the records of the patient should be in media, that is a type media, that is in software, so what is called as a computer media. Yeah, so that should be recorded in that. They have given even the instructions that the old record should be converted into soft media. Yeah, within 3 years from their order, and 1 year has passed. So after the 2 years, that it has become a compulsion by the NMC that it should be written in the soft media only. You should not write. Actually, medico-legally also, you should not write anything on the OPD case paper, because whatever you write on the OPD case paper, that goes to the patient, that goes is the court. And if by chance you written something which is against you, that is used against you. Particularly, our doctors are having the writing of question marks, question marks, question marks. So this is corneal infection, question mark. This is keratitis, question marks. This question mark. And these question marks, we understand these question marks are differential diagnosis. It is not the question that is bind. Doctor is confused. But the advocates of opposite side say that doctor was confused. He was not knowing anything. He was not knowing the diagnosis. He was not knowing even the treatment. So he was confused. So he has put the question mark.
Provisional.
Yeah. So never put a question mark on your inpatient also or outpatient also. But whatever three things you have to write, you write to your hospital record and nothing on the OPD case paper except treatment and the follow-up. Follow-up should be very good written on that. Next date, emergency dates, and the phone numbers and even personal phone number of the doctor.
In the EMRC, it is always written there is no question mark. It is a provisional diagnosis. So even if you are mentioning it physically,
Yeah.
better mention it as a provisional
Yeah,
diagnosis
writing
rather than
provisional
putting a question
diagnosis.
mark.
No question marks.
The important thing is don't give your case records to the patient, OPD case records. In my clinic, the patients ask me for my case paper. I said my case paper is in handwriting because I don't use EMR as yet. My handwriting, sometimes even I cannot read. So it's impossible for you to read. Instead of that, you just wait for 24 hours. I'll give you a printed case summary. So you can give a printed case summary in which you can write whatever you like and give it to them rather than a case record with P equals N, which in my languages, pupils were normal. So P equals N is, if I give it to him, he's not going to understand, neither his advocate will understand. So better not to give, because they said, sir, we got a mobile phone, I'll just click. It's so, I said, no, sorry, you will not just click because you won't follow. I'll give you a typed report which you can use. Yes. Yes. No, exactly. Never give your worksheet to the
Actually
patient.
speaking, there are programmings also. Programs are available. Lot many softwares are available for hospital, and that can be made tailor-made also. As you like, you can make your software tailor-made and put a operator by the side. You just go on dictating and she or he types it and it goes to the computer. And in the last, only the prescription comes. Whatever you say, the prescription comes out and it becomes very easy. And nowadays, after 2 years, it will be mandatory because NMC wants that. NMC don't want the prescription should be in handwriting. And if it is in handwriting, it should be very, very clear. Yes, please. Follow up, with follow up. Yeah. No, no, nothing should not be given.
But if
I
the
will
patient,
say,
as it is his right to have a case summary.
yeah. If he applies for case summary, you can give the case summary.
No, you have to write the case summary.
Yes, yes.
Yeah. Yeah, yeah. Unless they require and apply. Whenever they apply, within 72 hours, you have to give that. That is their right.
You can't charge.
And you cannot charge for that.
You cannot charge. You can charge only for photocopy charges. They can't charge. Legally, you can't charge. I'm pretty sure. Yeah. If you see American doctors' reports, they write 4 to 6 pages of gibberish for a conjunctivitis patient, but it's that thick. They don't write the essence, but it's all covered in so much of junk that you can hardly decipher.
Yes, please.
Yeah. They're not supposed to, you can stop them. Yeah. What can you do without knowledge? If you come to know, you can stop it.
If you do a slim damage stuff here, probably the patient will not come.
Yeah.
Slim damage stuff is done in USA. They write everything.
We are finished our time, so I thank you all, our speakers and our audience. I thank you everybody for even software people and all that. Thank you very much. एक photograph घ्यायचा